Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
In today's video, we are going to discuss private defense under Bharatiya Nyaya Sanhita 2023, section 34 to 44.
Today, we're going to tackle a topic that is absolutely fundamental for your judiciary, APP, and LLB exams, the right of private defense. Specifically, we'll be mastering sections 34 and 35 of the new Bharatiya Nyaya Sanhita. Trust me, a solid understanding here is crucial, so let's jump right in. So, here's our game plan. We'll start with the very idea behind this right. Then, we'll get into the specifics of sections 34 and 35. After that, we'll look at how courts have interpreted this, which is super important. We'll walk through some practical examples, and finally, wrap up with the key points you absolutely need to remember for your exams.
All right, let's begin at the beginning. You see, the right of private defense isn't something the law gives you out of generosity. No, it's a recognition of a basic human instinct, the instinct to protect yourself. The law simply puts a formal structure around this natural right.
This brings us to the most important question, right? When can you actually use force to defend yourself and not end up on the wrong side of the law? What are the lines you cannot cross? That's exactly what we're here to figure out.
So formally, under the BNS, this right allows you to use necessary force against an unlawful act to protect your body and your property. And not just your own, but someone else's too. You know, the law doesn't expect you to be a sitting duck and just wait for help to arrive when you're in immediate danger.
Now, this is a critical distinction you have to remember. This right is purely preventive and defensive. It is not punitive. It's not about punishing someone for what they did. It's about stopping them from causing harm right now. It's a shield to protect yourself, not a sword to strike back later.
Okay, let's get into the actual text of the law. We're going to break down the two core provisions in the Bharatiya Nyaya Sanhita, sections 34 and 35. For those of you familiar with the old law, these correspond to sections 96 and 97 of the IPC.
Section 34 is our foundation. It's what we call a general exception, and it's incredibly powerful. It says that an act that would otherwise be a crime, say causing hurt, is not considered an offense at all if it was done while exercising your right of private defense.
But of course, there are conditions. For this defense to hold up in court, three things are essential. 1. The act must genuinely be for private defense. 2. It has to stay within the limits prescribed by law. We'll get to that. And 3, and this is key, there must be a reasonable apprehension of danger. It's not about what you imagined, it's about what a reasonable person would fear in that situation.
So, what exactly can you protect? Well, Section 35 lays it out very clearly. The right extends to two things: your body and the body of any other person, and secondly, your property, whether it's movable or immovable, and the property of any other person.
Now, reading the law is one thing. Understanding how it's applied in a real courtroom is another. This is where judicial precedence becomes so important. Let's look at the conditions the courts have laid down and some landmark cases that have shaped this area of law.
When a case of private defense comes before a court, they essentially run a three-point check. First, was there a genuine, immediate threat? Second, was the force used proportional? You can't use a cannon to kill a mosquito, right? And third, was there any time to run to the police or other public authorities for help? If you had a chance to call for help but chose not to, your claim of private defense might be weakened.
Okay, everyone, please make a note of this case. Darshan Singh versus State of Punjab. This is a landmark Supreme Court judgment that meticulously lays down the principles governing the right of private defense. For your exams, this case citation is non-negotiable. You must know it.
So what did the court say in Darshan Singh? Well, it reiterated that the right is to prevent a crime, not to retaliate. Crucially, the court said that a person facing an attack can't be expected to measure the force they use with golden scales. You have to be realistic about the panic of the moment. And finally, for the accused person claiming this right, the burden of proof isn't beyond a reasonable doubt. It's preponderance of probability. You just have to show that your version of events is more likely true than not.
All right, we've covered the theory. Now let's put it to the test. Applying these principles to practical scenarios is what will really solidify your understanding and, frankly, it's what will score you marks in your exams. Let's see the crucial difference between defense and retaliation.
Okay, first scenario. A comes at B with a knife.
B picks up a nearby stick and hits A, injuring him. Is B protected by the law? What do you think?
Yes, absolutely. This is a classic, textbook example of valid private defense. B was facing a real and immediate threat of grievous harm from a deadly weapon. The force used was a reasonable response to neutralize that threat. Now, let's change the facts a bit. Let's say a fight has already ended, the immediate danger is gone, but one of the individuals, D, feels aggrieved, goes home, grabs a weapon, and comes back to attack the other person.
This is a clear no. This is not private defense. Why? Because the threat was no longer immediate. The act of going home, getting a weapon, and returning shows premeditation. This isn't defense, it's a planned act of revenge, and the law offers no protection for that.
Let's look at one more, this time dealing with property and that crucial principle of proportionality. A pickpocket tries to snatch a wallet. The victim, instead of just shouting or pushing him away, pulls out a gun and shoots the pickpocket dead.
This is a definite no-go. The force used was grossly disproportionate to the threat. Yes, the victim had a right to protect his property, but using deadly force against a simple pickpocket is not justified. This would likely amount to a serious criminal offense.
All right, we've covered a lot of ground. Now, let's distill all of this into the most critical points that you need to carry with you into your exam hall.
This table is really important because examiners love to ask questions that test your ability to distinguish between similar-looking defenses. For private defense, the threat comes from an aggressor. For necessity, it comes from circumstances, where you choose a lesser harm. For compulsion, you're being threatened by a third person. And remember this key difference. Only private defense, under very specific circumstances, can justify an act that results in death.
So, to summarize it all in 4 simple rules. 1. It's a defensive right, never an aggressive one. 2. It's available for both your body and your property. 3. It is always subject to the rule of proportionality. And 4. It can never, ever be a cover for revenge. And if there is just one line you remember from our entire discussion today, let it be this one. Private defense is a shield, not a sword. It is a means of protection, not a license for aggression. Thank you for your attention, and all the very best for your studies.
Today, we are tackling a critical question that goes to the very heart of the law and self-preservation. We're going to dissect a very important and often tested provision from the new Penal Code, Section 36 of the Bharatiya Nyaya Sanhita, 2023. This section deals with a fascinating side of the right of private defense, and by the end of our discussion today, you will have absolute clarity on it.
So, let's get right into it. The right of private defense. On the surface, it seems pretty straightforward, doesn't it? If someone attacks you, you have the right to defend yourself. But the law has to account for situations where things aren't so black and white, for those complex scenarios that happen in the real world. And this brings us to a really thought-provoking question. What if the person attacking you is someone who, in the eyes of the law, is incapable of committing a crime? Think about it. Maybe they are a minor or someone suffering from a mental illness. Does that mean your right to self-defense just vanishes? Are you supposed to just stand there and take it? What does the law say you can do? Well, the answer to this legal puzzle is found right here in Section 36 of the BNS. This is the provision that brings clarity to these very tricky situations. It establishes a principle that is both logical and just. Let's break down exactly how it works.
So, what does Section 36 actually say? Put simply, it extends your right of private defense to cover acts done by people who are legally exempt from criminal liability. This could be someone of unsound mind, a minor, or even someone acting under a mistake of fact.
Now this is the golden rule of this section. If you take away only one thing, let it be this. The law doesn't focus on who the attacker is or what their legal status might be. What matters is the act itself. What matters is the danger that act poses to you, the victim.
Okay, to really master this for your exams, we need to deconstruct it. We need to look at the essential components, the ingredients that must be present for this section to apply. There are 4 key conditions, so let's walk through them one by one.
First, there has to be an act that would normally be considered an offense. Second, the person doing that act is legally excused from criminal liability because of some personal incapacity, like being a minor or having an unsound mind. Third, and this is the trigger, you, as the victim, must have a reasonable apprehension of danger.
And fourth, and this is the crucial part, the law gives you the exact same right of private defense as you would have against a person with full criminal capacity.
Now, these ideas aren't new. They're built on solid legal foundations. The first maxim, vim vi repeller licet, is quite simple. It means force may be repelled by force. It's fundamental. The second one, though, is where it gets really interesting for this section. We know that a crime usually requires a guilty mind, a mens rea. But Section 36 tells us that even if the attacker has no guilty mind, your right to protect yourself remains completely intact.
Theory is one thing, but to really understand this, we need to look at how it works in practice. So let's go through some classic examples and see how the courts have interpreted this right over the years. This is where you'll really see the law in action.
All right, here's a classic exam scenario for you. A person who is legally of unsound mind attacks you. Because of their condition, they haven't technically committed a legal offense. So can you defend yourself? The answer unequivocally is yes. Section 36 is your shield. You have the full right to use proportionate force to protect yourself from harm.
And here's another one you are very likely to encounter. What if the person attacking you is a minor? Now, depending on their age and level of understanding, they might not be criminally liable, but the danger they pose can be very, very real. Section 36 confirms that yes, you are legally allowed to defend yourself proportionately against that attack.
This table really makes the core logic crystal clear. Just look at that final column. It doesn't matter who the attacker is, a sane adult, a person with a mental illness, a minor, or someone acting under a mistake. Look at the answer every single time. Yes, the legal liability of the aggressor might change, but your right to be safe, that remains constant.
And the judiciary has consistently backed this up. In the landmark case of Darshan Singh v. State of Punjab, the Supreme Court made it very clear that this right is a shield, not a sword. It's for preventing harm, not for punishing someone. Then, in State of UP v. Ram Swaroop, the court added another vital layer. Your apprehension of danger is judged from your perspective, in the heat of that moment, not with the perfect clarity of hindsight in a courtroom months later. These are crucial distinctions to remember.
All right, let's consolidate everything we've discussed. If you are taking notes, this is the time to pay close attention. These are the key exam takeaways, the core principles of Section 36 that you absolutely need to remember.
First, know the categories. This right is available against persons who are insane, minors, intoxicated, or mistaken. Second, remember the trigger. It's all based on your reasonable apprehension of danger. Third, the extent of your right is exactly the same as it would be against anyone else. And finally, always remember its nature. It is for defense, not for retaliation.
Now, one last procedural point, but it's a very important one that often comes up: the burden of proof. If you claim that you acted in self-defense, it is on you to prove it. But the standard of proof isn't beyond a reasonable doubt. It's a lower standard, preponderance of probability. You just need to show that it is more likely than not that your version of events is true.
So, to conclude, if there is one sentence that truly captures the entire philosophy behind Section 36, it's this: the law protects the victim's safety, not the aggressor's incapacity. The law makes a conscious choice. It prioritizes your right to be safe over the legal excuse of the person causing you harm. This ensures that the fundamental right to defend your own body and life remains absolute and just. Remember this principle.
Today, we're tackling a really important topic in the law of private defense. So let me ask you a question. We all know about the right to self-defense, but have you ever thought about when it's not a right? It's a tricky one, right? And for your judiciary exams, getting this wrong can be a huge problem. Understanding the details here is absolutely critical. Well, the answer to that very important question is found in Section 37 of the Bharatiya Nyaya Sanhita. This is the section that really lays down the foundation, setting the limits on this right. So, okay, let's get right into it. All right, so today we're going to discuss Section 37 of the Bharatiya Nyaya Sanhita 2023. Now, you need to remember that this section is basically the controlling provision for the entire chapter on private defense. It's the one that sets all the boundaries. Now, what does this actually mean in simple language? Well, you know how other sections give you the right to defend yourself? Section 37 steps in and says, hold on, that right isn't absolute. Think of it this way. It's supposed to be a shield to protect you, not a sword to attack others. The whole point of this section is to stop people from misusing the right of private defense and to keep a balance between your safety and, well, public order. Okay, so let's break this down. What are the specific situations where you just can't claim the right of private defense? So, Section 37 gives us 4 main conditions. Let's go through them. First, you can't use it against an act of a public servant. Second, you also can't use it against an act done under the direction of a public servant. Third, and this one's a big one, if you have time to call for help from the authorities, you can't claim self-defense. And finally, number 4, you can't inflict more harm than is actually necessary for your defense. Now, in this section, there are 3 really important legal terms you absolutely have to understand. First, public servant. This is basically any government employee who's doing their job. Second, we have good faith. This just means they're acting with an honest intention, without any bad motive or malice. And third is the phrase under color of office. This means the public servant is acting in their official role, even if what they're doing isn't perfectly by the book. Okay, so we've gone through the theory, but theory is one thing, right? Let's look at a practical, real-world example to make this whole concept crystal clear. All right, so let's imagine this. Suppose a police officer shows up with a valid warrant to arrest someone. Now, in this situation, the person being arrested can't just attack the officer and then say, hey, I was just defending myself. Why not? Because that officer is simply doing their lawful duty, and they're doing it in good faith. This table is super helpful because it shows the contrasts. Look at the difference here. If a police officer is acting lawfully, you have no right of private defense. Simple. But what if some random person just claims to be a police officer? Well, then your right is absolutely valid. See the difference? The 2 big takeaways here are proportionality and opportunity. You can't use a huge amount of force for a small threat. And this is so important. If you had enough time to call the police, your right of private defense is gone. You can't use it. To really understand how a section is interpreted, we have to look at case law. So let's check out 2 really important landmark cases that deal with this. Okay, first up is Darshan Singh versus State of Punjab from 2010. In this case, the Supreme Court made it very, very clear. The force you use in self-defense must be proportionate to the danger you're facing. What does that mean? It means you can't use self-defense as an excuse to get revenge. The key word here, remember this, is proportionality. Next, we have Munshi Ram versus Delhi Administration, a case from 1968. Now, this case clarifies that whole rule about having time to seek help. The court basically said, look, if you had a reasonable chance and enough time to call for help from the police or other authorities, then trying to use private defense just isn't justified. Okay, here's a very important point, especially for your exams. This section, Section 37, used to be Section 99 of the old Indian Penal Code, 1860. That has now been replaced by Section 37 of the Bharatiya Nyaya Sanhita, 2023. Make sure you know that. All right, we're almost there. Let's get to the final and maybe most important part for you, your exam-ready revision. This is where we'll pull everything together so you're perfectly prepared. So listen carefully. For both your judiciary prelims and mains, this section is absolutely crucial. And for the APO exam, you can definitely expect direct questions on this topic. Be ready for those problem-based questions that test you on each one of these conditions. Okay, time for a super quick revision. Here's what you need to remember. Point 1. Section 37 of the BNS 2023 is what restricts the right of private defense. Point 2. The core concept. There's no defense against lawful authority if you had time to get help or if your force was excessive. And point 3, your big exam tip, this is the controlling provision for the entire concept of private defense. And to leave you with one final thought, always remember this powerful principle. The right of private defense ends where necessity ends. It's as simple as that. The moment the danger is gone, your right to defend yourself is also gone. For more judiciary-focused legal content just like this, make sure you stay connected with us here at Ganda Education. Today, we're diving into a really, really important topic for your exams, the right of private defense of the body. We'll be looking at it through the lens of the new Bharatiya Nyaya Sanhita 2023 and focusing specifically on sections 38 and 39. So here's how we're going to break it down. First, we'll touch on the basics of private defense. Then we'll jump straight into Section 38, which is all about causing death. After that, we'll look at what the Supreme Court has to say, understand its counterpart, Section 39, compare the two, and then finish up with a super focused revision session for your exams. So what is this, right? Really? Well, you can think of it as the law's way of saying, yes, you are allowed to protect your own body from harm. But, and this is crucial, it's a shield, not a sword. The law gives you the right to defend yourself, not to take revenge or to attack someone. And this brings us to the biggest question, the one that often pops up in mains exams. When is it actually legal to use force that could kill someone just to defend yourself? Now, the law is very precise about this. It doesn't leave anything up to guesswork. In that precise answer, you'll find it right here, in Section 38 of the BNS. This section provides the entire legal framework. It tells us about those extreme, exceptional situations where taking a life in self-defense is actually considered justified by law. So to be very specific, आज हम discuss करेंगे Section 38 of the Bharatiya Nyaya Sanhita 2023. Make sure you mark this section in your book. It's absolutely fundamental when we talk about the right of private defense of the body. Okay, now look at the actual language from the VARE Act. It says the right extends to causing death, but only if the offense is of a description hereafter enumerated. What does that mean? It means this right isn't a free-for-all. It's only available in a specific listed set of circumstances. And here they are, the 7 grounds you have to know by heart for your exams. Let's go through them. The first 2 are about a reasonable apprehension. That means a genuine, believable fear of either your own death or of grievous hurt. The next 2, 3 and 4, deal with serious sexual assaults. Number 5 is about assault for kidnapping or abducting. 6 is when you're wrongfully confined, trapped somewhere with no way to call for help. And finally, number 7 covers the horrific crime of an acid attack or even just the attempt of one. Let's make this super clear with a practical example. Imagine A points a loaded gun at B. Now, at that very moment, B has a reasonable apprehension of death, right? Well, according to Section 38, B doesn't have to wait to get shot. B is justified in using deadly force first to stop A. This shows that the right is all about prevention. All right, so the BEAR Act gives us the rules in black and white, but it's really the Supreme Court judgments that tell us how these rules work in the real world. So to write a truly complete answer in your exam, you have to know how the courts see this. Now for your exam notes, these 4 cases are non-negotiable. You have to know them. We have Darshan Singh versus State of Punjab, State of UP versus Ram Swaroop, James Martin versus State of Kerala, and versus Singh versus State of Punjab. Go ahead and jot these down. In the landmark case of Darshan Singh, the Supreme Court said something incredibly important and practical. The court said that a person who is defending themselves can't be expected to measure their response on golden scales. In the heat of the moment, you're not going to be perfectly precise, and the law understands that. The right to defend yourself starts the second the fear becomes real, and it lasts as long as that danger is still there. This is a golden line for your mains answers. Okay, so we've talked about the 7 situations where causing death is allowed, but what about all the other types of attacks? Well, that's exactly where Section 39 comes in. It basically draws the line for self-defense in less dangerous situations. Section 39 of the BNS is actually very simple. It just says that if the attack you're facing is not one of those 7 serious threats from Section 38, then your right to private defense does not allow you to cause death. You can still defend yourself, of course, but only by causing some other harm that is less than death. So, for instance, if someone just slaps you, you can use enough force to push them away, but you definitely cannot kill them. It's all about proportionality. Now, to really get a handle on this topic, it's best to look at these 2 sections side by side. You can think of it as a ladder of force. The law says that the force you use in your defense must be in proportion to the threat you're facing. This table makes the difference really clear. For Section 38, the threat has to be a grave one, and it must be one of the 7 listed in the law. In that case, yes, causing death is allowed. But for Section 39, which covers every other kind of assault, causing death is a big no. The harm you cause has to be less than death. Understanding this difference is absolutely essential. All right, let's switch gears and focus completely on your exams. These next few slides are your quick revision notes, the things you absolutely must remember for your judiciary and APO exams. So pay very close attention. First up, a very common question in prelims, how does this compare to the old law? While ये section पहले IPC section 100 था, जो अब replace हो चुका है by the Bharatiya Nyaya Sanhita 2023. And in the same way, today's section 39 used to be section 101 of the IPC. You have to remember this mapping. Let me be very clear about this. Judiciary prelims और mains दोनों के लिए ये sections बहुत important है. You can bet on getting direct questions about those 7 grounds we discussed. And if you're preparing for APO exams, questions based on the case laws we talked about are very, very common. So, let's do a super quick revision. 1. Sections 38 and 39 of the BNS define the limits of this right. 2. The core concept is simple. A grave threat justifies causing death under Section 38. A lesser threat only justifies lesser harm under Section 39. And 3. It's a high-yield topic for your exams. Remember the 7 grounds and the golden scales rule from the Darshan Singh case. And that's a wrap on this crucial topic. The right to defend oneself is fundamental, but the law requires it to be exercised with reason and proportion. For more judiciary-focused legal content, stay connected with Ganga Education. Today, we're going to break down a really crucial concept for your judiciary exams, the right of private defense, as it's laid out in the new Bharatiya Nyaya Sanhita. So, here's how we're going to tackle this. We'll start with an introduction to this section, then get into the nitty-gritty of when the right begins and when it ends. After that, we'll look at some real-world examples and a key court ruling, and then we'll wrap it all up with a summary perfect for your exam prep.
All right, let's dive right in. आज हम डिस्कस करेंगे सेक्शन 40 of the भारतीय न्याय संहिता 2023. Now, this section is all about the commencement and the continuance of the right of private defense of the body.
So why is this section so important? Well, it basically answers two fundamental questions. First, at what exact moment does your right to defend yourself actually begin? And second, how long does that right last? You see, in the eyes of the law, timing is absolutely everything, and Section 40 gives us the precise framework for that. Now, this is a core legal principle you absolutely have to remember. Private defense is meant to be preventative, not punitive. What that means is the law gives you a shield to protect yourself from harm, not a sword to go and punish someone. Keep this distinction in mind. It's so important, especially for your mains answer writing. Okay, let's move on. Now we're going to look at the exact wording of the law to understand the starting point of this right. In simple language, what this means is that you don't have to wait to actually get hurt. Your right to defend yourself kicks in the very moment you have a reasonable apprehension. That's a genuine, justifiable belief that you are in danger. And this is true even if the attack itself hasn't even started yet. So, to really get a grip on this section for your exams, we need to break it down into its most important parts, its key ingredients. Let's take a look. Is section में 3 important चीजें हैं. First, reasonable apprehension. This just means there has to be a real and justifiable fear of danger. Second, commencement. This is the start line. The right begins as soon as that reasonable fear pops up. And third, continuance. Now this is the crucial part. The right lasts only as long as that threat continues. The moment the danger is gone, your right is gone too. You know, theory is one thing, but to really understand it, you've got to see it in practice. So, let's go through a quick scenario that makes this whole concept crystal clear. This slide illustrates the difference perfectly. Look at the left side. That's a valid defense. A threatens B with a knife, so B acts immediately to stop the attack from happening. That's self-defense. Now, look at the right side. This is retaliation. The attacker is running away, meaning the danger is over. If B then chases and attacks them, that's not private defense anymore. That's revenge, which the law does not allow. For your mains exams and, of course, your interviews, understanding landmark Supreme Court judgments is non-negotiable. So let's look at a very important case on this topic. The case you see on your screen, Darshan Singh versus State of Punjab, is a landmark judgment when it comes to understanding this idea of reasonable apprehension. In this particular case, the Supreme Court held that the right of private defense is anticipatory. What does that mean? It means you don't have to wait around to actually get injured. The right begins the very moment a genuine and reasonable threat comes into existence. Now, here's a quick point for your prelims. It's always good to know the old corresponding section. ये section पहले IPC section 102 था, जो अब replace हो चुका है by the Bharatiya Nyaya Sanhita 2023. All right, we're now at the final and maybe the most important part for your prep, a quick revision of everything we've just covered. Let's be very clear about the exam importance. Judiciary prelims और mains दोनों के लिए ये section बहुत important है. You should fully expect to see direct questions on its commencement and continuance, especially problem-based questions in your mains and APO exams. So let's do a super quick revision. First, the section is 40 of the BNS 2023. Second, the core concept is simple. The right starts when you reasonably fear danger and ends the moment that danger is gone. And third, for your exam, the keyword to remember is timing. We really hope this breakdown of Section 40 was helpful for your preparation. For more judiciary-focused legal content just like this, make sure you stay connected with Ganga Education.
All right, let's jump right into two sections that are absolutely critical for any judiciary aspirant. That's sections 41 and 42 of the brand new Bharatiya Nyaya Sanhita. We're talking about the right to defend your property. Now, this is a hot topic for exams, so let's make sure you are more than prepared.
So, let's start with a really simple, direct question to get us thinking. Picture this. It's broad daylight.
and you see someone running off with your bicycle. You catch them red-handed. The question is, can you legally use deadly force to stop them? The answer is, well, it's complicated, and it gets to the very heart of what we're going to unpack today.
Here's our game plan. We'll kick things off with the absolute basics. Then we'll dive deep into those rare cases where causing death might be justified. After that, we'll cover the general rule of proportionality, see how the courts actually interpret all this, and then, my favorite part, we'll hit some practical examples and common exam traps so you don't get caught out.
Okay, first things first, let's build our foundation. You see, while other parts of the BNS talk about defending your body, these sections, 41 and 42, they lay out the very specific and much stricter rules for protecting your stuff. So here's the bottom line, and it's a big one. The law absolutely gives you the right to use force to protect your property. But, and this is a huge but, it values human life above all else. What that means is that using deadly force is the absolute final last resort. It's reserved only for the most extreme, the most dangerous situations. And that brings us to the specifics. Let's talk about Section 41. Think of this as the major exception to the general rule. This is the section that carves out those very few, very precise circumstances where the law says, okay, in this situation, causing the death of an attacker to protect property might just be justifiable. Now, what's so fascinating here is how specific the law is. It's not about a feeling of danger. It's a checklist. Deadly force can only be on the table in one of these four situations. 1, robbery. 2, housebreaking, but, and this is key, specifically by night. 3, mischief by fire or explosives, but again, specifically against a building used as a home or for storing property. And 4, theft or trespass that makes you genuinely and reasonably fear for your own life or fear grievous hurt. For anyone studying for an exam, this slide is pure gold. This is your mental checklist. For a defense under Section 41 to even be considered, all 4 of these things must be true. It has to be an offense against property. It must be one of those 4 grave crimes we just listed. It has to create that reasonable apprehension of death or grievous hurt. We're talking serious, life-altering injury. And on top of all that, it's still subject to the general rules in Section 37, like you can't use more harm than necessary. So if Section 41 is for those absolute worst-case scenarios, what about, well, everything else? That's where Section 42 comes in, and this section is all about one single crucial word, proportionality. And this chart just lays it out so clearly, doesn't it? It's like night and day. On the left, you have Section 41 for extreme danger, armed robbery, a break-in in the middle of the night where your life is on the line. But on the right, you have Section 42 for everything else, minor theft, simple trespass. In those cases, the law is crystal clear. Killing the offender is absolutely not allowed. You can use force, yes, but only the amount of harm that is proportional to the actual threat. Of course, the words in the law book are just the beginning, right? What really matters is how judges take these rules and apply them in the real world, in a real courtroom. So let's look at some landmark cases that really define this entire area of law. This point from the Supreme Court in Darshan Singh versus State of Punjab is so important. The court basically said it all comes down to that reasonable apprehension. It's not just about what you personally felt. The real test is, would a reasonable person standing in your shoes in that exact moment have also been in fear of their life or serious injury? That's the standard. And then you have the famous K.M. Nanavati case, which really doubles down on this idea. The court hammers home the point that deadly force to protect your property is reserved for only the most extreme cases. And it even gives a direct example from the law itself, housebreaking at night. It connects right back to that specific list in Section 41. And in State of U. P.V. Ram Swarup, the court gave us this incredibly useful practical framework. When a judge is looking at a claim of private defense of property, they're going to systematically look at these 3 things. The timing, was it day or night? The seriousness of the crime itself. And finally, the proportionality of the force you used in response. It's like a 3-point test. All right, theory's done. Now for the fun part. Let's put all this knowledge to work. This is where we go from just knowing the law to actually using it to ace those tricky exam questions. Think of this table as your ultimate cheat sheet. An armed robbery? Yes, Section 41 could apply. A thief breaking into your house at 2 a.m. Again, you're looking at Section 41. But, and this is the big but, someone snatching your bicycle in broad daylight or a simple trespasser in your garden? Nope. That falls squarely under Section 42, where deadly force is completely off the table. Okay, everyone, listen up, because this is the #1 trap I see students fall into time and time again. The exam question will describe a theft, and it's tempting to just label it and move on. Don't do it. The real question, the one that gets you the marks, is always about analyzing the context. Was there a reasonable apprehension of death or grievous hurt? That's the question behind the question. Answering that correctly is what separates a good answer from a great one. And a quick word on procedure, because this stuff definitely gets tested. First, it's on the accused, the person who used the force, to actually say, hey, I was defending myself. The court won't just assume it. Second, remember, the court is going to look at the threat objectively, from a reasonable person's point of view. And finally, if you go too far, if you use what the law calls excessive force, your entire claim of private defense could be thrown right out the window. So, after all of that, let's boil it down. What's the one key takeaway, the golden rule you need to remember for your exams and for truly understanding how this law works? Here it is. The right to defend your property is not a simple on or off switch. It's a graduated scale. It's a spectrum. Think of Section 41 as that tiny red alert zone for life-threatening emergencies. Section 42, on the other hand, is the general rule. It's the default setting that governs almost every other situation, and it always demands a balanced, proportional response. And we'll end on this one line. If you remember nothing else, burn this into your memory. Deadly defense is reserved for grave property offenses. Trivial theft allows only proportionate harm. Understanding that single distinction is not just the key to passing your exam, it's the key to understanding the profound balance the law strikes between protecting our things and, more importantly, preserving human life.
Today, we're diving into a really important topic for your upcoming exams, Section 43 of the Bharatiya Nyaya Sanhita 2023. This section deals with the right of private defense of property, and we're going to get into exactly when this right starts and, crucially, how long it lasts.
So, here's how we're going to break it down for you. First, we'll get to grips with the core concept of Section 43. Then, we'll decode its key ingredients. After that, we'll see how it all works in the real world with some practical scenarios. And finally, I'll share the most important focus points to help you nail this in your exams.
All right, let's start with the core concept. You see, Section 43 is all about answering two fundamental questions. When can you actually start defending your property? And just as important, when do you have to stop? This section gives us the whole framework for the timing and duration of this right.
So today, we are going to discuss Section 43 of the Bharatiya Nyaya Sanhita 2023. This is the law that now governs this right. Now, this is the key line right from the bare act. It says the right starts when a reasonable apprehension of danger commences. So what does that really mean in simple terms? Well, it means your right to use force kicks in the very moment you genuinely believe your property is in danger. You don't have to wait for the damage to actually happen.
Okay, so now that we have the main idea down, let's break this section into its key parts. Understanding these components is absolutely essential for structuring your answers well in the exam.
Think of it in 4 simple steps. First, it all begins with a reasonable apprehension of danger. Once that's there, we move to step 2. The right commences or begins. Now, step 3 is really crucial. The duration of this right isn't unlimited. It actually changes depending on the specific crime. And finally, number 4, and this is a big one, any force you use must always be proportional to the threat you're facing.
This is a point you have to remember. How long the right lasts depends on the crime. For example, in a case of theft, your right to defense continues until the thief gets away with your property, or you get the property back, or the police arrive. But for a much more serious crime like robbery, that right continues as long as there's an immediate threat of death or harm. Do you see the pattern? The right is directly tied to how long the immediate threat from that specific crime continues.
So we've covered the theory, but how does all this work in practice? Let's make it crystal clear with a straightforward example, and then we'll look at a landmark court case.
Okay, here's a classic exam-style example for you. An armed robber enters a shop and threatens the shopkeeper. Now, that shopkeeper's right of private defense is active as long as the robber poses an immediate threat of death or harm. The second that threat disappears, say the robber drops his weapon and runs away, the right to use force also ends.
Now, let's talk about a landmark case that you should definitely remember. In Darshan Singh versus State of Punjab, the Supreme Court stated very clearly that the right of private defense of property continues for as long as the threat to that property persists. This is a very important ruling that really solidifies the core principle of Section 43.
And now we're at the part that's probably most important for your preparation, the exam focus. Let's break down why this section is so critical and what kind of questions you should be ready for.
It's really important to know the legal history here. This provision used to be Section 105 of the Indian Penal Code. It's now been replaced by Section 43 of the Bharatiya Nyaya Sanhita, 2023. But, and this is key, the fundamental principles about when the right starts and how long it lasts have been carried over from the old law.
Okay, listen up, because this is crucial. This section is extremely important for both the judiciary prelims and mains. In prelims, you can expect direct questions about the duration of the right for specific offenses. In the mains, you're more likely to get situational problems that test your analysis. And for the APO exam, well, there's a very high probability you'll see direct questions on its core concepts.
So let's do a quick recap of the key takeaways. Remember, it's Section 43 of the BNS, 2023. The right kicks in with a reasonable apprehension of danger, and how long it lasts depends entirely on the specific crime being committed. Make sure this section is at the top of your revision list for your prelims, mains, and APO exams.
And that wraps up our breakdown of Section 43. I really hope this explanation helps with your exam preparation. For more judiciary-focused legal content, make sure you stay connected with Gunga Education.
All right, let's dive into one of the most intense and, honestly, complicated questions in the entire legal world. What happens when saving your own life might mean harming an innocent person? Today, we're getting into the nuts and bolts of Section 44 of the Bharatiya Nyaya Sanhita 2023, which is the law's answer to this incredibly tough moral problem. So, to really get this, let's jump right into a high-stakes scenario. Just imagine it. You're being swarmed by a violent mob. You genuinely believe they are going to kill you. Your only way out is to fire a weapon. But wait, there are innocent children mixed into that crowd. What do you do? Do you act? Do you freeze? This is way more than a movie scene. It's a real-life dilemma the law has to face. I mean, this is what you'd call an impossible choice, right? On one side, you have this fundamental, primal right to defend your own life. But on the other, you have a deep responsibility to protect innocent people from harm. So how on earth does the legal system even begin to untangle this? Well, at its very core, the law has to perform this incredibly delicate balancing act. It totally recognizes how precious your life is and your right to save it. But at the same time, it has to think about safeguarding people who have nothing to do with the attack. And that tension, that's exactly what Section 44 was created to solve. So what's the solution? The law provides something you can think of as a legal shield, and that shield is Section 44 of the Bharatiya Nyaya Sanhita. Now, the exact wording here is absolutely crucial. Listen to this. The law says that if you're facing a deadly assault and you absolutely cannot defend yourself without risking harm to an innocent person, then your right of self-defense extends to running that risk. Did you catch that? The law explicitly says you are allowed to take that risk to save your own skin. But, and this is a huge but, this powerful right isn't some kind of get-out-of-jail-free card. It is not an excuse for being careless. For this legal shield to actually protect you, the law lays out 5 very specific conditions that have to be met. No exceptions. Let's break them down. You can think of these 5 points like a checklist. First, there has to be a real deadly assault happening. Second, you have to genuinely and reasonably fear for your life. Third, there is literally no other way to save yourself without putting an innocent person at risk. Fourth, that risk has to be completely unavoidable. And finally, number 5, the force you use has to be necessary and proportional to the threat. It's a high bar, for sure, and you have to clear all 5. Now, Section 44 wasn't just invented out of thin air. It's actually built on a foundation of some really old, time-tested legal wisdom. These are principles, often in Latin, that help judges understand the very soul of the law. The first, and maybe the most important principle, is necessitas non habet legem. It literally means necessity has no law. It's this powerful idea that when it comes down to life or death, when necessity is driving your actions, the normal rules can bend. It's the law's way of saying, hey, in the most extreme situations, survival can justify an act that would normally be off limits. And that idea flows right into a second one, vim vi repellere licet. Basically, it is lawful to repel force with force. This backs up your right to fight back. The law allows you to meet a violent attack with your own defensive force, even if, tragically, an innocent person gets caught in the crossfire. And look, this isn't just theory. The courts have stood by this. In the huge case of Darshan Singh versus the state of Punjab,
The court was crystal clear. It said the right of private defense can cover situations where innocent bystanders might get hurt by accident. This puts some serious judicial muscle behind the law. Then you've got another major case, State of UP versus Ram Swaroop, which gives us the key question the court will always ask. And that question is, did the defender have any other choice? Was the risk to that innocent person truly 100% unavoidable? If the answer is yes, then your claim of self-defense has a very good chance of holding up. Okay, so we've covered the law, the conditions, the principles. Now let's bring this down to earth and see what this looks like in the real world, both when Section 44 applies and when it absolutely does not. This slide gets to the heart of it. On the left, the person is acting out of necessity. The threat is real, it's happening right now, which makes the risk to the bystander tragic, but legally it's considered unavoidable. But on the right, the person is acting out of pure recklessness. There's no threat, so hurting a passerby isn't a justifiable risk. It's just a crime. That is the crucial line that Section 44 draws. All right, for all of you who are prepping for judiciary exams or just deep into your law studies, this next part is for you. We're going to boil this all down to the absolute must-know essentials. Okay, for your exams, you need to lock in these key phrases: reasonable apprehension of death, unavoidable risk, and proportionate force. You should probably expect to see this stuff tested in scenarios involving mob attacks, riots, that kind of thing. And most importantly, you have to be able to explain that crucial difference. Was the harm caused by an unavoidable risk, or was it just plain old reckless endangerment? And that brings us to what I'd call the golden rule that wraps this whole topic up. If you remember one thing, let it be this. In deadly defense, unavoidable risk to innocence is excused. Deliberate recklessness is not. It draws that perfect line in the sand. It protects the desperate act of someone trying to survive, not the careless actions of someone who's just being reckless.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.